Okay, 9B, discussion and possible action regarding legal representation. Ms. Carson.
Thank you, Mr. Chair. I mentioned in the end of the call meeting that I wanted to, actually I had asked then that the law director share with us or come back and let us know about some of the proceedings in that call meeting. I'm sorry, I'm trying to get out of here. I don't really want a long drawn out. I want to go back to the issues that are pertinent, at least in my opinion, at what happened in our called meeting related to the contract. First, it was after lengthy discussion and public forum, Ms. Roundtree made a motion. She made an objection to the question. And the law director, I know that I looked and said, wait a minute, and a number of other people did, and the law director ruled that that motion was appropriate. A very quick look at Robert's rules will tell you that if you're going to have an objection to the question, it may be raised only before debate has begun, otherwise it is out of order. And it is very clearly written in the very beginning of that discussion. The law director also said it takes a 2/3 vote to overrule the objection.
However, in stating that, I said the Roberts Rule says that it takes a 2/3 vote to overrule the objection.
Yes.
And I said, but, and then everybody exploded. Well, you've always said, and I held up my hand and I said, yes, 5 votes.
No, sir. Well, I went back and looked at the
Look
tape.
at it.
I did. And
Well,
that
well-
part of that discussion was not related to the 2/3 to overrule. In fact, it takes a 2/3 vote to sustain,
Sustain.
not overrule, and that's very different.
It's exactly the same.
No, sir.
If you sustain the objection, you overrule the motion. You can state it, you overrule the motion, or you sustain the objection.
If you know that you know this board operates 5-4, then how you word it matters very differently. True? If you know you're not going to have 2/3 anyway, do you word it affirmatively or negatively? And that's the difference. I will just say, in Robert's Rules, it requires a 2/3 vote to sustain, is not debatable, and is classified as an incidental motion. The objection may only be raised before debate has begun on the motion.
Now, let me clarify as to why I said that it was a proper objection.
Okay?
We started off at the beginning of the meeting with a motion to approve a board's version.
Mm-hmm.
Some hours later, we're still amending the motion and the version. In the end, you asked me, even after the objection, I said that we could have the objection of the motion to the question. You asked me, and I said, you said, what do we need to do? And I said, you need to make a new motion that would get you where you want it to be. And then I said, but I'm not going to tell you how. And I will tell you what I was going to say that very night, but I thought, well, you know, that's going a little far. It's trying to tell the board what to do, and I'm not going to go there. But what had happened during your whole process was we had an original motion. Then we changed every element of that motion as we went. And it was voted on all the way, seemingly. However, there were also times when the chair said, this particular item, we don't need anymore. We're just going to throw it out, and then we moved on. Then we voted on the next one, and then we voted on the next one, always changing the question. Then in the end, what I was going to say and decided not to was, we need a motion to approve the board's version as amended and recommended by the chairman. That would take care of all of if any ambiguities as it went down. But I didn't say that.
Well, I will just say that to tell me now what you would have said and should have said really doesn't serve a purpose for what I will just, if I can have the floor, and I promise you, yeah, I would guess the chair will give you a chance to debate. I will say that we asked specifically, what is the objection to what question, because there were many questions in that document. It came down to the ambiguity at the date. And that did not change from the board's version that was initially in there. That did not change. That was the same question that was put out initially. I did hear in the motion that when we finally voted, the contract listed as board version as amended with amendments throughout. At any rate, subsequently after the vote, the law director made a decision that he could not sign the contract as being in legal form, and made the decision to insert the word "not" in front of the approved legal form and correctness, as opposed to simply not signing the form. Ethically, your decision to make. But by inserting that word "not," it's as effective as putting a highlighter on there and saying, hey, everybody, ask me about this. When that decision was made, I would think, as a board member, our board would be notified of that decision. The way we found out was to read the commission agenda. It's not the communication I would expect. The board may feel differently as a whole. But I will say that that discussion then generated significant misunderstanding among county commission as I observed their meeting. There were some who continually referred to the document as illegal. You made effort to make sure they understood you were not saying it's illegal. You were questioning its enforceability. But it did bring that confusion. And it brought that confusion to commissioners who are much more informed about the proceedings that go on. The confusion it created for the general public, we have no way of measuring those things that happen. It came down to then a question of what the Attorney General would say. As far as I can see, this board has never been given the question that was asked to the Attorney General. I've got the emails from you, or that were sent to Doug and copied to the board. I can't find what the question was, and it's very significant. It's kind of like my point in the beginning of sustain or overrule, or, deny a motion. So if you ask a question that says, can the board extend the superintendent's contract? To me, that's not the question. The board did not vote to extend the contract. The board clearly voted to renew the contract. So I don't know what the question was. And I would ask, and I know that we have asked, that when any board member communicates, if you could please just communicate to all board members, it will make it much easier. At any rate, in the very end, we received an email from your office on 12/31, and it says, the Attorney General has opined that it is legislative intent that a 4-year superintendent contract cannot be extended to more than 4 years. Agree. It can be renewed at the end of each 4-year period. I don't know that I saw that in what you sent to us, but it still doesn't, to me, ask the question which we discussed in our meeting is, can the board renegotiate as the director of schools contract? Or does the board, as I understand you to say, have to wait until that contract fully matures before they can do that? Now, I will ask, is that, my understanding of what you wrote is that the contract must fully mature before the board can do that. Is that true or not?
That is true.
Okay. So, given that, I then asked a number of attorneys.
Good.
And I worded the question without any reference to anything. My question simply was, can a Board of Ed renew, renegotiate, the contract of the Director of Schools following an annual evaluation, or must they wait until the contract fully matures before taking any action.
Okay. And the answer to that question is yes.
Absolutely, yes.
But you said, may we renew?
Yes.
Okay. It has nothing to do with a 4-year duration.
No. And that-
Renew is, I want to amend the contract I have. I gave you one in legal form that addressed that very issue and all the other legal concerns of that contract. And the one you're particularly focusing on is the one that you said subject to the Attorney General opinion.
No, actually, I said if there is an opinion from, because I think you were misleading in what I observed in the county commission meeting, that a board member asked for an Attorney General opinion. I never asked for one. I heard that that was the question and concern, and frankly, if there is anything in this contract that we later determine is against TCA, it's already void. It's
That's right.
nullified.
That's right.
So this was to satisfy the concern that, oh, we can't put that in there. Well, we might be able to. It's ambiguous. We could, we can't, the 4 years. But we can, within a 4-year window, it is absolutely okay to put 2016 to 2019 in a renewed contract.
No. You cannot extend a
That's
duration.
not an extension, it's a
It is.
replacement of.
No, what the Attorney General has said, you cannot have the statute says you cannot have a contract greater than 4 years.
Absolutely.
Absolutely. And that the legislative intent, and if you'll read
I did.
the case law and the Attorney General, is that each, and Dr. McIntyre said that today, he said it would be just so that incoming boards can evaluate and determine their own. If you continue to 1 year, 1 year, 1 year, 1 year, you can actually create a contract that is beyond a 4-year term of an incoming board, and they have no say. And that's the legislative intent of the duration of 4 years. It doesn't say, no, you can't extend it, but you can if you do this. It doesn't say you cannot extend it, but you can if you do this. And it doesn't say you cannot extend it if you do this. It says, no, it cannot be extended that 4-year duration, but it can be renewed. If you have a driver's license, you don't renew it at year 2 and make it year 6. You don't renew it at year 3 and make it year 7. You don't renew it. That's not the normal, common use of a contract renewal.
Well, I will just say this. I will say there is not a board that I have found in Tennessee that follows the practice of awaiting the expiration of a superintendent's contract before they renegotiate a new one. There is not a single board that I could find that do that. That is not the practice, and it is my belief that your opinion, and I, again, have asked that question, and it's all informal, that your opinion on this is wrong. Why is this important? Because I think that there has been a picture presented, intentionally or unintentionally, that 5 members of this board chose to sign a contract that wasn't really to form. That was not the choice that I made as a board member. I think it's important that the board get another opinion, and then at least it gives the opportunity to say, because if you're going to live under this belief, it's wrong. It's wrong. Now, if I'm wrong, another opinion will say.
Can I call a point of order at this point?
In a discussion, sure. I mean, what's a point of order in discussion?
Well,
There's no
I just
motion
feel like
on the
this
floor.
has become political, and I just
object.
think we need
I
to move
object,
on.
Mr. Chair.
Yes.
There is no motion on the
finish.
floor. There's no point of order.
Yep, there's no motion. It's just a discussion, so you'll have a chance to say your
Thank
piece in a
you.
few
Can we
minutes.
ask questions, though?
Well, let's let Ms. Carson finish.
Sure.
We'll let her finish.
So at this point, given the concerns that I have, given the responses that I have received, I think it's important that the question be answered. And I think that there is definitely a perception, an assumption that a board cannot renew a contract. replace the old one, put in a new one, which are exactly the words that are in the contract, with new dates. I agree, it cannot be more than 4 years. And I think that resolves the legislative intent. So my intent is not to go beyond that, but to, on Wednesday, just ask that this board agree to put this question out to a second opinion. I think it needs to be paid for. I don't know lawyer fees, but I can't imagine $500. I don't know. We can set a cap limit on it, but I think it's very important, and I think, you know, there are many things that are ambiguous, and if you're not the expert in that area, you have to yield to the expert in the area. But when there is blatant misinformation, in my opinion, I, as a board member, have a fiduciary responsibility to get the question answered. Thank you.
Okay. Mr. Lawdicker, you want to respond?
All that's well and good. I hear exactly what you're saying. However, as a board member, you also have taken an oath to uphold the laws. And this particular community has stated very succinctly that there is one legal opinion. Whether you like it or whether you don't is totally immaterial. There is one legal opinion. The charter as presented by this community says that the Knox County Law Director is in charge of all legal affairs of the county, and that the Knox County Law Director is in charge of counsel and advice of all the legal matters as it relates to the elected officials and county commission. That's the end of that discussion. And that no one in this county can hire an attorney without the approval of the Knox County Law Director, period. That's been adjudicated, that's been decided. It is like you saying, I don't like the way the mayor paves the street, and I think we need to get some other opinion as to how he paves the street. The streets affect you, but it's outside your jurisdiction. The legal representation and the legal advice that you get to this board affects you, but it's outside your jurisdiction. It is the legal affairs of an elected official beyond this board. When I advise this board, when I talk to this board, I stay out of your policy. I don't get in your sandbox, as they say, as across the street. I advise you, and on this particular contract, there was over 160 years of legal experience went through that, through the holidays, through Thanksgiving, through the weekends, to come up with a legal document in form and in measure. And the not you're assuming had to do with the first element of that contract. That's what you're saying, and that's the part that's giving you heartburn.
Nope, it's the only one that I'm choosing to address right now.
Well, then you can
There's no assumption.
you can choose to address it. And the vote of this board on anything related to that matter has the same effect as the vote across the street on anything related to Dr. McIntyre's contract. You can vote 9-0 to do what you're saying, but then you're in violation of the laws of this community and in violation of your oath of office. And I'll just let it lay there. So you have no jurisdiction over this topic. You can express it politically as you have done tonight. You can bring it before this body and the community at large, and you're welcome to do that. I don't get in your sandbox, and I'll guarantee this board is not going to get in the Knox County Law Director's sandbox. If you want our advice and our guidance, it's there. I have to give it to you by law. And you will get what I think and what my organization believes is in the best interest of Knox County and the taxpayer. Mm-hmm. And it's just like a Supreme Court or any other court of more than one judge. It may be a 5-4 vote, but in the end, it is what they say it is. Mm-hmm. And when this law director gives you an opinion, it may be a 5-4 vote, but in the end, it is what it says. And I'm not accountable for any other county and any other board and any other government in this state, but I am accountable for this one. And it's the only opinion you're going to get. And that's the way it is. Mr. Chairman, I'm through.
Which one of you?
Amber.
Ms. Fugit?
Thank you. I just had a question related to this. Mr. Law Director, if that is the legal opinion, and you're the only person that can give us a legal opinion, I will share publicly, I have concerns competitively when we go to hire a superintendent. If every other superintendent around us and their school board does contracts differently, I just think the board needs to think about that, because if we can only hire a superintendent and it has to run out for 4 years, I mean, I hear what you're saying. I'm just saying that is something we need to think about as we look to replace the superintendent. And I guess my question, and I am not being antagonistic, you clearly have said you are the law director and your opinion goes. My question is, what happened? Did all the other law directors miss this? I mean, and I'm not being funny, I'm not being facetious, because the other thing that played out publicly, and you talk about playing politics, the other thing that played out publicly is that basically it left the impression that a Board of Education has been doing something it's not allowed to do with nobody looking over their shoulder for years. And I came on this board in 2010. My understanding is Charles Lindsay's contracts were this way, Alan Morgan's contracts were this way, and this has been the practice of the Board of Education forever, and there have been many law directors prior to you. So I just want on the public record that this board was not doing anything to defy you or in spite of you. This board, I, in good faith, am operating on the fact that I had always been led to believe by every other attorney that what we were doing was legal.
Right.
You are now the law director and you have a different opinion and you say that's the way it is. But I just want the public to understand, because I believe it got confused in there that there are a bunch of people trying to hoodoo something and lie and give Dr. McIntyre a golden parachute, I heard, you know, which is just nothing further from the truth. I voted to extend the superintendent's contract, renegotiate his contract, to give him a 4-year contract, because I thought he had done a good job and I wanted him to stay our superintendent.
I understand that.
And that is my understanding of why boards of education renegotiate contracts with superintendents, hoping they will stay. I hear you, but I'm just saying I want the public to understand this board, this 1 year, did not do anything that it hadn't been doing for 10, 12 years. And I just want the community to understand that this board was not trying to do an end run around the law, because you're the first law director that has given us this opinion.
The law director is not ever even thinking or implying that was the case, because even on issues...
No, but the community got that impression, so I appreciate you saying that.
No, I never applied that. There were other things in the contract that also, and the contract before that, we talked about things that were, I think the words that I used were probably unenforceable. Because if they never come up, we don't know whether they're going to be enforceable or not. And my job is to look out for what's in the best interest of Knox County. And that's what we did. And also, not just going back into the law and looking at the legislative intent, I actually talked to some legislatures about what their intent was. And I got the same answer as what the court gave me. I didn't just say, well, you know, Anderson County does it this way, or Granger County does it this way, or whoever you're talking about does it. I don't care what other people do. I'm only responsible for the citizens and taxpayers of Knox County. And I would never, ever, and I'll tell the public out there, imply that this board would try to do anything intentionally illegal. And that's why I'm telling you now, on your Wednesday issue, if you vote to do what was implied, that's illegal. It's against the charter of Knox County, and I'm advising you about it now. So either way you want to go, you do what you do. But I had left this board. This board had made its decision. We're done. Now I've got to go across the street with a consent agreement where it says that the mayor has to determine legal form and availability of funds. I have to go over to another group of clients and say they have to know whether it's in legal form and is it appropriated for. That's a whole different set of people talking a whole different conversation. This board, its action's done. This board has already spoken, and I made that clear to everybody, that this board has total authority and autonomy over the hiring of a director of school, period, done. I said that till I was sore from the get-go. However, I could not tell the mayor of this county that it was in legal form, and I could not tell commission that it was in legal form, whatever those ramifications were. And so I had a different responsibility to a different group of people for different reasons. Commission needed to know, but their vote was totally immaterial. The mayor, however, needed to know because his signature or not is executed one way or the other. He needed to know how to deal with it. So that's where all of that came from, but that, even though it impacted a board's decision, had nothing to do with this board. It was advising completely different elected officials and in their different capacities, and that's what the charter tells me to do, to advise and counsel the elected official on the legal matters affecting their responsibility.
Can I ask a question on that? I mean, I think that the way that this consent decree has been set up is it puts every law director in a position where they have a conflict of interest. And just basically what you were just saying there to me is you have a conflict of interest, not because you're a bad person, but just the way it's set up. You've got one set of clients here, now you've got to go over into another set of clients. And that consent decree talked about the conflict of interest. And I mean, would you not agree that there is a conflict of interest, that it's not your fault, that that's just the way it's been set up?
No, because that's a whole different term. And now we're going to talk about a conflict of interest. And a conflict of interest, according to the Supreme Court, a governmental attorney, and this is different than private attorneys, cannot have a conflict of interest in advising their clients because their clients are not always in the same vein. The legal conflict comes as if somebody's suing you and somebody's suing the chairman of the commission, and one of you's wrong. Okay, now I've got a problem. Now I have a legal conflict. So then I will probably have to hire outside counsel for both, and you get to pick yours. That's what that consent agreement says. But there is never and cannot be, and the Supreme Court has already said that, a conflict of interest based upon a counsel or advisory opinion in a government lawyer, because it is inherently, budget money, conflict here. I mean, there's struggles within the process. And all we're doing is saying, what is the legal matters and how do they affect your responsibility? Then the mayor, how does it affect yours? The mayor, for example, y'all didn't have to do anything. You voted. And you had an offer. It was good. I said that. We left. But from the mayor's perspective, for example, he had to know, if I don't sign this, like you said, the law director could have just left it blank. What does that say? But if the mayor doesn't sign it, it becomes active as in legal form and in availability of funds within X number of days. Well, he can't leave it blank, but he can't sign it because it's not in legal form, because now he's in a conundrum. So what do? So he has to ask. And then I have to advise him as how these legal matters affect his responsibility and what he has to do to get the communication back to whatever it is he wants to do. The same was true with my commissioners. So the advice is the same. The reality and facts are the same. This board did nothing wrong in terms of what it proposed to do and wanted to do. But the answers to the questions on the other side were different because they have different official responsibilities, and I had to tell them something that would affect these legal matters that were created here would affect their responsibilities. And under the law, which puts me in a position, I'd have no choice. And just like in this room, I can say the lights are on, it's going to make half this board happy. I can say the lights are off, it's going to make half this board mad, or vice versa, because of the dichotomy of this board as it currently sits. So that's why the Supreme Court says you can't have a conflict giving counsel and advice. Because I can have a conflict within my own board that I'm sitting with, and generally I do, and that's what's going on tonight. So
No, sir,
anyway, I'm done with this
may-
topic.
Well, no, sir, my question, I wanted to ask, and this really is not about conflict. I think more than anything, would it be improper for you to have let us know that was going to happen? I think it's a matter,
Of taste.
your opinion is your opinion, and I hear what you've said all about the law, and I'm not a lawyer, so I can't debate that with you. But I do think it is troubling when you sit on an elected body and you've done work and you find out that the work you've done is going to be viewed differently, and you find it out in the paper. It would have been nice to hear from our attorney.
Well, I found it out
that-
in the paper too.
No.
That I said the contract was illegal. I never.
But I mean, just the fact that you put the word "not" on the contract and we found out about it because it was on the consent agenda, that's really it. It's more of a feeling of lack of respect for our role as a Board of Education, which has been happening a lot over the last few years in this county. That the Board of Education decides some things, and then we don't find out about it otherwise. So it feels a little, I would have thought, I understand you represent lots of people, but I would have thought my attorney would let me know
Well,
that he was going to, and I understand you're not my attorney.
that's right.
And, but just out of courtesy, in the future,
Well, dear.
in the future, I would just ask,
I hear you.
could you let us know if there are things that we do that you're going to have to portray in a different light to another one of your clients? So as an elected official, I am not blindsided by reading about it in public.
Okay. Well, I tried my best to let you all know all along the way when you were doing this contract. I don't think that's enforceable. Can't use liquidated damages. I have a problem with the standard of review. I don't believe you can extend this. I can't go so far in this board and say, you can't do that.
So.
You see what I'm saying?
Yes, sir. So your answer is, you told us, we ignored you, and you're not going to worry about doing it in the future, letting us know? Or are you going to try to let us know?
That is nothing, is what I said, right?
Okay, then I apologize. So in the future, you will try to give me a heads up?
I'll try to give you a heads up,
Thank you.
yeah.
That's all I asked
But also in the same vein, this board hit me with a contract, and it was like warp speed. It had to be done immediately. I've got 2 years left on this contract, and it has to be done immediately, and you have to have it done right this second, and I have to have it done today. And I say, I can't. Well, you have to. And I say, well, I have some problems, and I'm told I don't care. And I'm still working with it, trying to get this thing done. And then I say, I will have you one in legal form by Monday at noon. I missed it by an hour. And we worked the whole time to try to get it to you. So there's two sides to every corner of what's going on. And I'm not mad at anybody. I'm just saying, whoops, I would like a little courtesy too. But sometimes I don't get it either. And sometimes it's by the nature of the system. And by the time we had it over there and the time we got to review what we really had again, which was the first time the law director had seen anything that was laid here, it was different. I saw the words, I saw what had been changed, and I know why, but the effect was still the same. So I looked at it on its surface and said, oh, well, okay. And then in the end, I had to wait, and I got a copy, finally come over, logged in, we reviewed it. And I'm reviewing it for another client. You see where I am mentally? So we will try to be.
I'm just saying, it puts this Board of Education, and I understand this is not your concern, because you are the legal person for Knox County, but the charter form of government puts this Board of Education in a position that no other Board of Education is in the state.
You've got that right.
And
That is absolutely
it creates, I believe, an unnecessary hardship on this board and on our attorney to try to represent all sides, because we don't have an attorney that just represents us and gives us advice just on our issues. And I know that there's nothing you can do about that, but I do think that it is probably one of the frustrations that you're sensing from some of us, is that it is difficult when you travel across the state and you meet all these other boards and they talk about their board attorney, and who's your board attorney? Well, we have the county law director, and he's the attorney for the county commission,
Right.
and for the mayor, and for the sheriff, and for everybody. And so it really creates a conundrum for all those branches of government, actually.
Well, not really, because a lot, other than for school boards, everybody has that. So the conundrum exists for everybody across the state except for the school board. Except in Knox County, the school board's thrown over with everybody else in the same conundrum. So, and I think it's finally been stated here. You can go across this state and you can get legal opinions from every lawyer across this state, and it's not going to be what is affected here, because we have a entirely different governmental legal structure than any other place in Tennessee. And we have a set of rules that the citizens of Knox County have created that I have to say, here they are, here's how it affects you. Here they are, here's how it affects you. So we have a different purchasing code. It affects you differently than anybody else in the state. You know, I mean, there's just so much that this county does because it is a home rule, if you will, separate government of its own, and it changes every time an ordinance goes through across the street. And it could affect you, and it may not affect you. But in the end, this is the government that the people of this community have chosen, and whoever the law director is, they have the same conundrum to deal with, the ever-changing relationships of the law and the legal affairs and the legal matters as it affects each elected official and commission on their respective responsibilities. And that's what the charter says. And that's what I took an oath to uphold. No matter how much pain it gives me from some of my elected officials, it's the government that this community has decided it wants. And as long as Bud Armstrong is the law director, and I follow that oath, that's what this community will get. And I appreciate every person on this board. This is not a personal thing with me. And Dr. McIntyre have had these conversations before. And it's not a personal thing between Dr. McIntyre and me. It's just the nature of the legal structure of our government in Knox County. It's been adjudicated, it's been tested, it's been a element of contention for 15, 20 years, but it is what it is.
Okay.
Just going to put us at a competitive disadvantage trying to hire a superintendent.
Ms. Roundtree?
Thank you, Mr. Chair. I guess I just had a question about the proposed action. in Chancellor Bell's order of compromise, it states that in the event that the board or the county law director believe that a conflict of interest, as defined by Rule 8 of the Tennessee Supreme Court, exists between the office of the law director and the Board of Education, the law director shall appoint counsel to represent the board in those matters wherein the conflict is seen to exist. So I guess my first question would be to Ms. Carson, which part of Rule 8 do you believe that the law director is in conflict?
I didn't ever say that I saw a conflict of interest. You did not hear that from me.
Yeah, that was me talking about something else.
I'm sorry, I apologize.
That was asked and answered.
Okay. If you read that further in the order of compromise, it says that if it has to be submitted to the Tennessee Board of Professional Responsibility for an advisory opinion, which shall be binding upon the parties, in the event that the recourse is required, the board shall be entitled to hire its own counsel of its own choosing and at its own expense to represent the board's position before the BPR. And I guess my concern is, I would hope it would not be a lot of money, but I think we've mentioned this time and time again. We're on a very limited budget, so where is the money going to come from? And then how long is this going to drag out? And how is that going to affect our future superintendent search? And is that really what's best for the kids of Knox County?
Well, can I answer that?
Yes, go ahead.
I will reiterate for probably the 5th time tonight, everything I do here is related to what's best for the kids of Knox County. And I do not think it's best for the kids of Knox County, I don't think it's best for our district to go into a search for a new superintendent, believing that we can hire you for 4 years and we will not talk to you about any change in your contract dates until your contract expires. I firmly believe that is blatantly wrong. I believe it will hurt our ability to hire a superintendent. It is not the practice of any school in Tennessee, any public school district in Tennessee. All I asked, I didn't mention a conflict of interest. I said I want to
I
get.
apologize. I missed.
Well, I'm not even referring to the consent decree, because the only thing the consent decree talks about is if there's a conflict, that's all of that about paying for an attorney of our choosing, that's all related to a conflict of interest. There are many things in the consent decree that I have read many, many times, because there have been a number of times that I have believed there has been a conflict of interest. And I've explored that with the law director and with his staff. And so that, the consent decree also talks about county commission putting this on an education agenda and not putting it off. But the law director has opined that we can't hold, so that part of the consent decree isn't valid anymore. And so that is why I narrowed this down to a single question. And it's the length of contract and the ability, keeping within a 4-year limit, which is what the legislative intent is, but the ability to renew a contract. And I believe it will dramatically affect this board's ability to hire and keep a competent superintendent. That's why it's an issue to me. That's why I think it's a very, at the very best from my position, what will happen if we did this is a lawyer of somebody's naming comes back and says, I have a different opinion. It doesn't change where the board goes anymore, but what it does say is there is legitimately a concern, other than coming from a board member, that maybe this position needs to be revisited, this opinion needs to be revisited, needs to be looked at somehow. And it also clarifies to the public, this is an opinion. That's all it is. It's a legal opinion. I have heard time and time again, they can give, our legal counsel can give us our opinion. This board can then decide what it chooses to do. I will tell you this, I was not on the board when the board sued over these issues, but I can certainly say that I now think I understand better. It's, I will say that I resent and reject your statement that this has anything to do politically. I think that's an unfair assertion that you made about me. You said, as you've just done politically. This is a concern I have dramatically will impact, and it becomes more pertinent with the leaving of the superintendent, and that we can't address that, or we fear getting another opinion may differ or may be inappropriate to find out. Since when do we limit our ability to get information to a single source? And, generally, I'm okay with it. But when I believe and it's not having to do with any other part of the contract, just that one part.
And can I respond, please?
Yes.
And I understand that. I guess what I'm trying to ask is where is the policy, or where does it state in the charter that we have the ability to do that? Because my understanding is that the question was asked and answered, and Chancellor Bell ruled on that issue. That was why I raised the question. And then to the point that regarding the consent agenda, the agreement also states that they shall not be removed if the county executive has ensured that all proper procedures have been followed regarding availability of funds, legal compliance, so on and so forth. So my question then is, where are we given the authority to hire this person that you want to hire? That's all I'm asking. I would like to be directed to where the board has the power to do that. I don't.
5-4 vote. Five. You said 5 can do anything.
Well, I think it's been answered, so I'm going to go to Ms. Simon, and then Ms. Dethridge will be next.
Okay, thank you, Mr. Chairman. To me, I'm not going to address the opinion. I think I've been clear on that and where I stand on that. But I guess, Mr. Law Director, you just said that, you have to work for us. It's by law. You have to work for us. And so then I'm thinking that, yes, you are our attorney, and I would expect the same thing from you as an attorney as I would any other attorney that works for me. And so, when I say, and I guess I'm just really disappointed because, we had our meeting on the 30th, and yes, that was the contract date, the special called meeting. And then you were going to ask the Attorney General for a question, and then I also, and we talked about this, about how there was no paper trail for when that question was asked, and I told you I was disappointed about that because I get on Dr. McIntyre too about paper trails. And then, on December 14th, you sent a contract to County Commission, and we can go back and forth and agree to disagree that I think that was inappropriate, that, if my attorney was going to send something to another entity without letting me know that they were changing something, I would have a huge problem with my attorney. And then on December 17th, all of a sudden, I get a thing from WBIR that the Attorney General, we get the Attorney General's opinion, and my attorney's already giving out opinions to the local media without notifying his client, without notifying me. And if I had any other attorney that did that, I'd have a major problem, with that. And then the fact that our chairman emailed you on the 17th, I think it was, on the 17th, and said, WBR is reporting this, can you please give us your opinion on what you feel after the Attorney General's opinion came in? You on the 18th then said, yes, I'm going to prepare one. And I thought that was interesting timing because you hadn't even actually prepared a real statement, but you were talking to the media. And I think that if that, again, if that was my attorney, I'd have problems with my attorney not talking to me first before they talk to the media. And so then it goes to, and then one thing too, when we talk about not having opinions on things, or that, it's the nature of legal structure of our county for you to represent both. But I didn't feel like when someone said misleading, when my attorney is quoted in the Sentinel as saying that we fast-tracked that document, that is a negative thing, and it portrays a negative opinion of what that was. And again, I wouldn't want attorney giving opinions like that out. I just wouldn't. And I wouldn't keep that attorney if they did that, for sure. And then we have on the, and then you said that you weren't going to give, then you talked to the Sentinel and said you weren't going to give an opinion, and that was the same time that you said it was fast-tracked. And so then comes December 21st, and we still hadn't heard from you at all, any opinion written down in a statement. And all of a sudden, 5 hours before a county commission meeting, we get a letter, we get an email. I was really disappointed again in my counsel because it wasn't even addressed to the Board of Education. It was addressed to Brad Anders, the chairman of county commission. And I know that he had asked for an opinion as well, but so did we, your clients. So again, that sort of shows me that there's got to be some sort of conflict of interest because you never even addressed the Board of Education, which this whole question to the Attorney General was supposed to be for. And we heard it the same time County Commission did, 5 hours, so that we could not even have any way of saying, okay, looking into it. And I just thought it was really disrespectful, quite frankly, that it would go to County Commission before it came to the Board of Education. And again, I would have a huge problem. Wait, just let me finish, please. And then, and so I had a huge problem with that. And that was 21 days from the day of the meeting. And we waited 5 hours before that County Commission meeting to give your opinion on the enforceables. And I just thought that was a huge amount of time. And I wonder if County Commission or the mayor would have asked you to look over a contract or for an opinion if you would wait 21 days, to do that 5 hours before a really important meeting. And, and then December 31st, so 31 days after that first meeting on the 30th, was the very first time you addressed your client, the Board of Education, of your opinion, of another opinion. It was the first, whether or not I agree with that opinion or not is irrelevant. What I'm talking to you is about the service that I'm getting from my attorney. And I just, those are the issues that I'm having right now, because if we are your client and you by law have to work for us, that you said, then I expect more, because I have to have that information before it goes to another entity, regardless if I agree with it or not at this point. But I think respectfully, we should be getting this information not 21 and 31 days after we ask for it and you're sending it to other entities and you copied us on it. Mm-hmm. You did not even respectfully have enough respect to address the Board of Education as a whole. And I don't know if you did to separate board members, but as a whole, as the Board of Education was not addressed. And the chairman asked you, several days prior and nothing, but yet you will send something to them first. And that's what really rubbed me the wrong way. And again, if that was my attorney that I was paying for, I would look for another one, because all of those things I just listed are things that I would never allow an attorney to do, but yet it's happening. And I guess, obviously you've said that you're it. Mm-hmm. I got that loud and clear. Good. But in the future, I just want you to know I would expect more, because that's not acceptable. And again, we can agree to disagree, but as a Board of Education member and as your client who you're working for, I would like you to know that I would just expect more in the future.
Okay, my turn? Thank you. Number one, we're comparing apples and oranges. Commissioner Anders asked me a very specific question, which was completely different and less detailed than the chairman of the Board of Education asked. He said, what are the elements of the contract that you think are not enforceable? That's easy. And I popped that out real quick. It's a whole different ballgame when you say, give me the legal analysis of a question as it relates to the issue of the term of a contract. That's what the chairman asked for. 2 different questions, 2 different clients, 2 different things. Because it was similarly related, I CC'd the board on what I sent the chair, Commissioner Anders, but it was a different question than the chairman of this board asked me. So we're comparing two issues against two different things. I got to Mr. Harris's, and I wanted to make sure, I don't know how many different versions I tried to write to communicate with Doug, the chairman, to answer his question. During the unfortunate time, I take 1 week off a year. It happened to be that week, and I was working part-time on it too, and still trying to live a little life along the way. And that's no excuse for me not to, quote, get it to him. But I got it to him, even while I was off, and I tried to answer his question, and I did. And I CC'd the entire board at that time. But one was for one body asking one question, one was for another body asking another question. They were closely related, but they were not the same. And so I addressed his question to the point.
But do you not think that the school board, the Board of Education, would want to know all the details about those unenforceables as well before you submit it to the county commission as a client? Again, that's just what I would think, but I think too, again, WBIR knew your opinion before your client did. And
What?
WBIR, you were quoted on WBIR by Mike Danila on December 17th saying that there were many different things as unenforceable after the Attorney General's opinion. And that's what you said, and so then you can go back and read it. But you had not even told us that opinion, and that's totally different than what we're talking about with county commission. We're talking about you going and talking to the media before you let your client know what you were even going to say.
They asked me about the elements of the contract, same question I was working on for Mr. Anders, which was a different question that's over here. And they asked similar question to Mr. Anders. It had nothing to do with the question Mr. Harris asked.
But you hadn't even prepared that, because that was 4 days prior to the commission, Mr. Anders.
I understand.
So, again, I just don't know if our I think one of the best law attorneys I could ever have would be someone I don't even know their name, and they do what we ask and report to us before they report to other entities. That's all I'm asking, because again, some of the things that you brought up, I could just negate as well, just like we just did. And all I'm saying is that before you go to a different entity with information, I would appreciate if you would just let your client, the Board of Education, know that. And even if we didn't ask for that, I guarantee you, and see, that's sort of a conflict of interest in my mind, because here's the thing, is that if any other company, if I own a company and I have an attorney and there's a company that has another attorney, has a company here, and they ask my attorney for information to get to them, and my attorney doesn't let me know that information before they give it to them, that's a problem for me.
Absolutely.
And that's what happened.
No, it's not.
It's absolutely what happened.
You are a part.
I want you to watch those videos, because it's exactly what happened.
No, where you're missing the point, it's very succinct. There is only one client. It's Knox County government. You're Knox County government. If I give it to the mayor, I'm giving it to Knox County government. If I give it to Doug Harris, I'm giving it to Knox County government. If I give it to the sheriff, I'm giving it to Knox County government. I have one client. Now, because I tell the sheriff something, doesn't mean I have to run down the hall and tell the mayor
No, but
something.
it doesn't affect them. It
That
affects the two different entities, then you should let both entities know. And one actually that affects the most more, like sooner. And again, we're going to sit here, and I'm not going to go back here and do this whole thing back and forth forever. All I want you to know is that going forward, I would really appreciate if you would let your client, or a subdivision of your client, the law of Knox County, know what your opinion is before you give it publicly, and B, let us know what your opinion is before you go and tell someone else, and not trash it by saying fast tracking. That's all I'm asking, and then you can say whatever you want. We can be done, but those are just all my.
We're just done then. I think you got my opinion.
Ms. Dethridge, is your mic down?
Yes.
Okay.
And I'm not sure I can add anything to this conversation. I I just had a question because the law director made a comment that now our law in Knox County is different from anyone else in the state of Tennessee. Can you tell me again? Because I am having
Sure,
problems here.
that's okay. Knox County, about, I don't know all the numbers, there's 1, 2, 3, at least 3, so there's at least 92 counties that are constitutional counties, and they run just alike. And they get private acts, and they get approval by the legislature, and they operate the way Tennessee has operated for 200 years. And then there are several others, Shelby County, Davidson County, Knox County, who have decided to create their own separate and unique governments that are not constitutional governments. They are charter governments. And we created one here in Knox County, and that charter is the driving legislative body piece that creates us. We abolished our old self and created a new self, completely different than any other. I mean, Davidson County is completely different than we are. Shelby County is completely different than we are. And all three of us are completely different than the rest of the state. That's what I meant. We are an entity created by the citizens of Knox County in a government form that they wanted. And we're different. And it has a bearing on how we do our jobs and how the law affects each affected elected official in their responsibilities. It just is. I mean, it's what we have to deal with every day.
So even if we are a chartered government, are there certain laws, though, even throughout the state that we all have to adhere to, regardless?
Oh, yes.
So,
Yes.
but how we operate is what's the
Yeah.
difference, right?
Now, well, some of the laws are impacted by the charter. Sometimes the charter clarifies. Sometimes the charter defines what the state statute really is. And sometimes the charter deals with areas that the state doesn't even deal with at all. So you have a different set of laws. You have the charter, you have the ordinances and the resolutions, which are laws that impact Knox County. And then over here you have the statutes, which under this body is how you have your power and duties to run schools under Title 49. And those are state statutes that tells you how to run state schools. But at the same time, in implementing and choosing some of those, it affects those because you choose, say, purchasing, for example. It throws you underneath the charter, and then that's how that works. And your purchasing and your contracting and all those procedures that seemingly conflict with every other county is because of the charter and the choices that were made and how we do things here that are different than any other county. And
So does that
affects
make
your legal
it,
opinion.
so that kind of clarifies why Shelby, Hamilton, Metro, and all those have their own attorney, where we can't have our own attorney? Is that, I mean, because I was listening to what Ms. Roundtree was saying about Judge Bell's decision, that we can, if we have a difference of opinion from a law director, but we have to pay for it ourselves. So we can hire an attorney? Is that what I'm
No, you can
understanding?
hire an attorney if we have a legal conflict under Rule 8. And that, I gave you an example of that a minute ago. It's usually a lawsuit where I have one client in conflict with another. That's a legal conflict. Then, under the charter, the law director hires outside counsel. Usually, and I'd hire one for Doug and this board, and I'd hire one for whoever, the county commission. But under our consent agreement, I'd hire one for Doug and this board. Doug, tell me who you want to hire. I wouldn't normally ask that because the charter gives me the power to hire outside counsel and manage and execute all the legal affairs of Knox County.
Okay, only if we have that kind of,
It has to be a legal
has to
conflict,
be a
not
legal
just
reason,
because
not because we
don't
want
agree.
our own attorney, is what
Yeah.
I'm saying. We can't really hire, okay. Then I guess too, when we're talking about having all this conversation, and some of the opinion I would like, in your opinion, you tell us what's not what we can't do or what's wrong, I would like, how do we fix it? I would like for my attorney to tell me, how do we fix it and make it work? You know what the end result is, what we're seeking?
Yeah.
So how do we get there? How do we make it legal? So that's where I would like for you or whoever you designate as the person that we working with the board, is if we know what we're trying to get, I would like to figure out how we get there. I know we have issues that might be wrong outside of, in addition to telling me what's wrong, just tell me how we fix it. What do we need to do?
Well, Ms. Etheridge, on our particular issue that came up tonight, you had a copy that was right in front of you that fixed it. It was all in legal form. It was all in compliance with the law. It was perfect in what you wanted to do, except for one thing, and that was the time extension. It took care of every issue but one. So I told you how to fix it, and I can't help you get.
It was overridden by what was so wrong. Like, we can't use extend, but you can't use renew. You can't use, well, the thing was, we couldn't decide between extend or renew, and you asked for the AG's opinion. So, and then I was looking at some of the things, you were talking about liquidated damages, because we didn't know if we had the money, and then I think we went
Ms.
over.
Etheridge,
Yeah.
we've
Commissions.
got, hang on, I'm sorry, but our tape is going to run out in 1 minute, so we're going to have to take
Okay.
a break. Are you,
That's fine.
you
No,
can,
I was gonna ask him a question, but.
yeah, I think we're going to have to wait.
Okay.
So we're just going to have to take a minute break or so, and they'll tell us when the tape's reloaded.
Here and just-
Yeah, let's just stay here, and they'll tell us.
Okay.
comment like you could have gone to 1,000 other school systems and not had to deal with the specifics of tribal government, and it does pose a challenge. It is what it is, I mean, I don't remember voting for it, but.
Okay, we got the tape going again. So, Ms. Dethridge, I'm sorry we had to interrupt you, but
That's okay, I just wanted to understand, okay, I understand the renew versus extend, but I think the liquid damages you said was not legally enforceable. Is that because we did it as a lump sum versus monthly?
No, in the section that I gave you, the courts have ruled that liquidated damages are not available to government employees. And that then you fall under contract law, and that's what I had in my contract, whereby if you result in having some form of claim or damage, then you pay it on a monthly basis, and during that time, the other person is obligated to mitigate. In other words, if it's $10 and then I can go get a job for $5, then you only have to pay me the $5 difference. I have to be made whole. Instead of you giving me a $10 lump sum and I go out the door. That's liquidated. We can't do that. That's punitive to the government, and government employees are not allowed to have liquidated damages, so it just is. So.
Oh, okay, so if we fire him for no reason, we don't have to pay him?
No, that's not what I said. You can't pay him a lump sum settlement. You have to pay him monthly, just like you did Dr. Lindsay. And he is obligated, he or she or whoever it is obligated to go out and find a job and mitigate those damages and reduce those damages.
Oh, okay.
That's all.
Okay.
That's
In
all
other
it
words,
means.
because
Yeah.
If he finds a job, then we don't have to pay him for the rest of, it kind
You
of
pay the
reduces
difference.
the amount of the.
Yes.
Yeah, pay the difference.
That person has to be made whole,
Okay,
yes.
yeah, okay. I think the next piece, I guess I'm trying to, is termination of cause is not legal. And that was because if he was properly terminated, we call it the power to hire from them, I guess when you said that that was not enforceable, that means because he may have an opportunity to go back and have legal representation to come back against us, or, I mean, I'm trying to, this takes the power to hire and fire away from the board and gives it to the third party.
Right. This was talking about, under normal contract law, when you terminate, and you terminate for cause, we were, if I'm recalling what the instance that was in, is he goes through an administrative law judge, and then they rule that you're either right or wrong. The original contract, as we said, it would then default for without cause. Because someone else is telling you what you can or cannot do as a board, and that's like for non-tenured teachers for tenured teachers process. This is contract law. You can terminate him. You can terminate him for cause. You can terminate him for no cause. That is affected by the damages part, and that's done. That whole remedy is done with damages.
So the tenured teacher has the right, but not the superintendent.
Yeah, it's a different contract. Mhm. The way this contract was written, and you were giving him those services, but what it was saying is that somebody else can overrule the rule of the board, and I made it default back to without cause. And that was what we were talking about there.
So if we did not terminate, if he was terminated for cause, but it was not legal, he doesn't have a right to come back and take us to court, or per se, or, legally.
Now, what would happen if we
Have
terminated
statutory
the
rights.
cause and it was improper, then you would pay his damages.
Oh, we would pay his damages.
Yes.
Okay. And then I guess the next thing is the bonusing, is his contract is not,
There's nowhere that gives you the authority to give people bonuses.
He never
in
took it.
49.
okay. Okay. So I guess my question, we went through this, we went through every piece of the contract and talked about it, but I don't remember, I guess, us having the lengthy or detailed discussion on these items that you identified when you sent it back to Brad Anders. So I was kind of taken aback because I just didn't remember it. I guess, I don't know if I was in the right frame of mind, I don't know, but when we went through every piece, I thought we clarified all of it, pretty much except for the renew versus extension. So when I saw that we had 4 different things that were not legal in that contract, I'm going, I don't know where I was, I don't know what I was doing, but I do not remember it being this many differences in that contract that we had drafted up and approved. So I just wanted to get you to clarify that for me.
Ms. Bounds, are you,
No,
you're fine, okay. Let me say a couple of things before you can give a summation, I guess, if there's nobody else. I tend to agree with Ms. Carson. I think that we're at a competitive disadvantage because of this ruling, and, you know, good people can disagree. Mr. Law Director, I mean, I have consulted with several attorneys that confirm what Mrs. Carson has said, and that backed up by we're, I guess, the only district in the state of Tennessee that is going to abide by this ruling. Puts us at a competitive disadvantage. So I don't think that's a good thing for our students. I don't think that's a good thing for our school system. I don't think it's a good thing for the public, too, to think that we had broken the law or had signed a contract that was not legal to form when I think it was. So I'm not sure what the next step is going to be. I think that one of the things that people needed to know, too, is that the state of Tennessee allows every school district to have their own law director, their own attorney. And that was part of this agreement. I think I've talked to several attorneys in the last few days. Every one of them think it's illegal. It's bound this school board to a decision that's illegal. And you've been very clear to us that state law trumps other law. And I don't really we don't need to get into that maybe at another time. Let's just say we can probably agree to disagree on that maybe, but you do know that there is a state law that says that a local school board can have their own attorney. But the charters, we've made this agreement, I guess, however many years ago that we agreed not to. I didn't sign that. I was not on the board. So that, to me, puts me at a disadvantage now when I think it's wrong. So anyway, yeah, I think this decision it will impede us in hiring another superintendent, and I think it hurts us. So that's all I want to say. Ms. Carson.
Thank you. Just quick clarification on a few things. We keep talking about it has been adjudicated. I think it was partially adjudicated. There was a decision from a judge. It was appealed in a timely manner, and then there was a consent decree that was not a decision from a judge. It was the 2 parties came together and came to an agreement. So I just think that there are people who then hear the suit was finalized and things like that. The judge agreed to what was proposed by the 2 parties. Ms. Roundtree mentioned if there were a conflict, and we talked about you agreeing that there is a legal conflict and then the process is set. There is also a process when we don't agree whether there's a conflict that's spelled out on there, and that's where the board has to hire its own attorney to represent, which is a case where we're allowed to hire our own attorney to deal with that question. And so I think that's just an important part in there. And though charter rule does make how we have an attorney different than every other district in Tennessee, we're not so completely different that we don't follow TCA. And so my question has only been related to the interpretation of TCA 49 to 203A 14A. And that's our ability to have this, and I think it has to be addressed at some point. I think it has to be addressed relatively soon by this board. I would hope that there is a way to reasonably address it and not get into lawsuits and things like that, because it does affect us. And I would just finally answer to Ms. Bounds, this is why there's no file attached, because this is what this board needs to do, is have discussions. And it's lengthy and it's painful, but it's how you operate under sunshine and fully transparent. Thank you.
Okay, I think we're moving to public forum now.